Well, good afternoon, everybody, and welcome to today's C-SPAN webinar. We want to once again thank you for your participation. Some 320 registrants thus far for today's webinar, and I think that's because of the fine, esteemed panel of attorneys that we have for today's session. We'll be starting here in just a few minutes, but right now we just want to make sure that everybody can see the screens, which I'm getting ready to share, and we will go from there. So hopefully now you can all see my screen. Can you guys? Good. So we will start here in another 2 to 3 minutes and start promptly at 2. We'll have you out of here by 3:30 or thereabouts. We've got significant amounts of information to try and cover in the hour and a half that we have with you. So we'll get started here in another 2 minutes. So if you need your one last break before the hour and a half, take it now. Welcome, Aaron. Glad you're here. Aaron, if you can share your screen, that would be great.
Yep.
There we go. Aaron, you there?
I'm here. Can you hear me?
I can hear you. Can you share your screen? You're the only one.
Yeah, it won't let me. It says all the webcam spaces are currently being used. So, and that's what I was saying. I really look spectacular today. In fact, I think it's the best I have looked in years. So I'm
Listen, I'm more than happy to unvideo. So Aaron,
no, you try because
no, I don't want that. No, I don't want that. I just
Aaron, now you try. I turned mine off, so you turn yours on.
Okay. Oh, there I am.
Much better.
So do we now get to decide whether we agree with your statement or not, or
No,
is that later?
Gorgeous.
What the hell?
Gorgeous.
Maybe I was overplaying my hand a little bit. That's possible.
Well, once again, as it is right at 2 o'clock, you welcome all of our esteemed panel of attorneys. That was great. The good news is nobody has to see my face today, and we get to share all of you all instead. Again, welcome to today's webinar. We're going to start promptly now that it is 2 o'clock. A couple of the normal housekeeping reminders. This presentation is being not only telecast, but was also being recorded so that you can have the opportunity to return and review the information in the slide deck and maybe some of the URLs that are embedded within it, as well as the guidance from the attorneys that are on the call. The normal and obligatory disclaimer: this is not full-on counsel from all of these wonderful 6 individuals. It is a discussion and a panel discussion around the overviews and the broad topics contained within the various regulatory packages that are scheduled to go into effect later on at the end of this month at the 1st of July. And they're sharing their expertise and their information and what they're hearing and their views with you. But it is not the same thing as having legal counsel and going to these individuals if they are your counsel or your counsel for actual guidance. Did I do that well enough, guys, in terms of the disclaimer? With that, I want to go ahead and get started. We will be doing questions and answers as well. I'll be moderating and then looking to the questions. We have some embedded as portions of the agenda as we go through. But first and foremost, I wanted to send C-SPAN's appreciation to the 7 individuals we have with us today. Kate Carey from Cooley, Dennis Cariello from Hogan, Marin, Babo, and Rose, Chris DeLuca from DeLuca Law, and Rose Fretz, White, Goss, Gentile, and Rhodes. It's a mouthful, Chris. Yolanda Gallegos from Gallegos Legal Group, as well as Aaron Lacey from Thompson Coburn, Roger Schwartzwelder from Maynard Cooper Kale, and Jonathan Tarnow from Drinker Biddle and Reed. Thank you one and all for your participation today. We do have a great deal of conversations to go through, and we appreciate all of your participation. C-SPAN definitely also would like to thank all of you and several other attorneys that are a part of the attorney roundtable that we've been doing now for just shy of a month on every Thursday to kind of walk and talk through information amongst and between ourselves. We here at C-SPAN find it very helpful and hope that you all do as well. And we very much thank you for your participation. Today, as previously stated, we're going to go through just a brief encapsulation because each of these regulatory packages in and of themselves have been the focus of webinars by all of these esteemed panel members and so many others in terms of the devil of the details that are included within. What we're going to try and do today is provide you with a refresher course of some of the highlights, the fine points of the various aspects of the regulatory packages scheduled to go into effect, remind you of early implementation and some of the things that you probably have already done, especially with regard to gainful employment that we'll talk about here in just a few minutes, but then go through portions of the presentation and reminders of the regulations that we just want to make sure that you have got a handle on as we head into the end of this month and the beginning of next month. Again, it will be, this is focused on regulations scheduled to take effect July 1st of this year. The first is gainful employment. This is actually the Federal Register notice from, so far back that it's kind of hard to remember that we saw this first on July 1st, almost literally a year ago now. But we were certainly all, I think, very happy when we saw what the department and the secretary had chosen to do. It is not probably lost on any of you that that regulation provided for a rescission of the entire rule. That meant all of the requirements, including not only the publication of information on your website, but all of the reporting requirements and all of the other information. It was scheduled to go into effect July 1st of this year. However, the department and the secretary used her authority to grant the opportunity for early implementation of the regulations. So literally up to a year ahead of time, institutions that found and saw the information could go about utilizing an early implementation caveat to start that process much sooner. Literally, upon providing a memo to file, not one even having been submitted to the Department of Education, but a memo to within the institution that showed that they were seeking to early implement the guidance and therefore focus on all of the rescissions with regard to gainful employment. What you can see at the bottom of this slide, just in case you don't have it handy or want to refer to it, but I think in this case in particular, probably well beyond that phase, is the actual Federal Register notice at the bottom of the slide. So with that, guys, before we go into borrower defense, anything you want to add? I mean, obviously, this is one of the few that we really have already fully, I think, digested and implemented. But any reactions or any things, especially with regard to the forms, that any of you might like to add to the discussion here?
Hey, Tom, one thing I would add is that I have noticed in reviewing school websites that there are still a number of schools that have gainful employment disclosures on their websites, even though they have said that they've rescinded and they've early adopted. So I think that that's something you may want to check and clean up your website if you still got those gainful employment disclosures on your websites.
And in addition to what Chris just said, I know for some schools, they actually have to have publications of outcomes information for other reasons, and they were relying on the gainful employment disclosure as sort of the cover for that. And so I would suggest that you just, if nothing else, change the title and link names so that it doesn't still say gainful employment, because I think it's confusing and it kind of belies the fact that you've already early implemented the rescission. So if you're still using the data, that's fine, but call it something else so you don't create that question.
And now, are you able to see my screen? There's some people that were saying that we weren't seeing the tracking before. So that's all you really missed was the list of the panelists, the oversight agenda with the dates, and then the fact that we are talking about the new regulatory guidance and the gainful employment information. Thank you for that. I hope everybody's seeing the screen now. I had it on pause. Again, technical difficulties and errors on my part. Sorry for that. At least I got the six of the 7 individual panelists up on the screen. Thank you for that, guys. Let's move on to one of the other major portions of regulatory revisions, and that's the borrower defense regulation, which was published republished back on September 23rd of last year, again with a July 1st implementation date, and certainly greater depth and detail in terms of the fine points with regard to this proposal. I'll go through the slides and then open it up for again, a great deal of discussion amongst the group here. With regard to borrower defense to repayment, there's the federal standards and process. The entire process was changed in terms of the way in which the borrower defense was going to be reviewed and assessed prior to the 2016 regulations versus the changes that came about as a result of the 2019 regs. And as a result of that, it was for student loans dispersed on or after July 1st of 2020. A considerable number of changes we'll talk about as well. Some of the additional guidance and additional changes the department is they'll talk about the additional changes the department has made even subsequent to this regulation. In addition, borrower defense included the fact that the secretary had new authority with regard to taking action from the schools with regard to financial loss and finding ways in which to seek the opportunity for remuneration back to the department. Key issues, again, for many of our institutions, if not all of higher education, were the revisions to pre-dispute arbitration agreements and class action waivers. You'll recall that the 2016 regulations, in essence, repealed and removed all of that information from enrollment agreements and other information. The 2019 regulations sought to put that back, but do so with clear information as a part of borrower entrance counseling as a portion of that new process, so that the individuals and the consumers, it was hoped, could be more informed by that process. Several things with regard to financial responsibility, changes as it related to adverse actions and with the financial condition and financial protections. Additionally, the definitions and terms used to calculate a composite scores were changed based on the accounting changes under generally accepted accounting principles. Another major issue for our portions of our community, revisions to the lease obligations and long-term debt, all of which we've discussed in the past and all of which have been things that are portions of the major changes with regard to borrower defense. Many of you participants on this call and the attorneys were part of those negotiations and did a hell of a job, in my opinion, and I think the community owes you all a debt of gratitude for not only the individuals that participated, but the collaboration that was done within the community around a lot of these regulations. So all of you individually or collectively, give you the opportunity. We've got significant amount of time spread out here to talk about all of these individually or in particular. Given that this is the first major regulatory package, I'd like to open it up to each of you to provide 3 minutes or so of your opinions and your key topics on this that you're dealing with your clients. Ladies always go first. So Kate, I'm going to give you the first opportunity, and then we'll go from there.
Wow, exciting. So I would say probably the first thing that has come up, and I imagine this is true for the rest of the panel as well, is the arbitration provision language and what does that mean and how do we deal with that? And I'm sure also my esteemed panel has also been seeing a lot of sudden litigation for our client schools with the closures and suits about changes to the modality of the education, and I paid for a residential program and now you're giving me online. That's not what I wanted. And what about my housing? And what about my food plan? And so we're seeing a lot of litigation. So this arbitration situation is obviously coming up a lot right now. So I think the note that's on the slide is basically sort of covers it. They removed from the regulation the entire section, which was the last part of the 2016 rule that prohibited the pre-dispute arbitration and required all the notices and the ban on class actions. All that language is gone. So as of July 1, 2020, you will be able to remove that language from your enrollment agreement or your arbitration agreements. If you have them that has the current language from the department, you'll be able to remove that and go back to your standard provision if you decide you want to stick with arbitration. The one thing I would add to what is in this bullet is that the language of the rule says that you have to have this, it has to be 12-point font, mind you, and the notice has to be publicly available. It says it has to be on the admissions webpage, but essentially what they're saying is it can't be on an internal web portal, like an intranet. It has to be something that any prospective student could see. So putting it on your main web page, I mean, that doesn't have to be on your homepage, but it has to be on the main web page that any public person could access. And 12-point font. So that one I'd say is probably coming up a lot. And just sort of sidetracking on this, if you're an institution that is now being faced with lawsuits because of everything that's happened with COVID, this is a real issue, how that is being, if you have an arbitration provision, how that kind of plays in. So make sure that you talk to your lawyer, whoever on this panel that might be, about how that's going to play in. So that's probably the biggest thing, or the most questions that I've gotten. I think the second, and I'll go brief on this because I don't want to take everybody else's time, is the change in the financial triggers. So the old versus the new, it was quite different. It's still a 10-day reporting requirement, but what you are reporting now is much different than it was under the 2016 rule. I'd say probably the biggest change that a lot of schools will be happy to hear is in the 2016 rule, anytime you got sued, regardless of what you were being sued for. I fell down the stairs, whatever. You wouldn't let me on the elevator. Someone stole my bike, whatever litigation you might have had, regardless of the amount of money, regardless of the claim, you were required to report it to the department. Under the new rule, it is only related to state or other governmental actions, and you don't have to report it until it's over. So instead of this, like reporting it after 10 days after a complaint, and then 10 days after a motion for summary judgment, and then 10 days after, you don't have to do any of that anymore, which I think will be a great relief to schools, because there was always a lot of questions about what am I supposed to be doing, and I report stuff and I never hear anything again. So that is a big change, and the triggers themselves have changed, but the ultimate composite score calculation is still the same. So they're still going to assess whatever the liability is to determine if your composite score drops below a 1. But there's a lot of different things that are looking at that are a little bit less cumbersome and draconian compared to what was in the 2016. So I'll stop because there's lots of other people on this panel that will have lots of other things to say. But those I think are the biggest for me, the two that I've had the most questions about, and the lease and long-term credit, but I'm leaving that for Jonathan.
And I was going to turn to Jonathan and/or Chris DeLuca because there's a lot of focus that those individuals, along with Aaron in particular, had on the lease obligations and the long-term debt. So, gentlemen, toss up. Jump ball. Who wants to go first?
I'm happy to go. So I feel like we should use Washington speak, and I thank the gentlelady for her comments and yielding the floor with this larger group.
I yield my time, Mr. Tarnow.
Exactly.
Well, I'm worried about how many schools have bicycles that get stolen, though. That's
yeah, that one I have exactly. I would agree with everything Kate said. I think I think the distinction between what is, and I won't repeat what Kate said on this point. I think the distinctions between what schools have gotten used to, just sort of figured out how to report all these different trigger events. So it really is only in the last year that people have had to really focus on that, given how the 2016 rule went away and then it came back. And so it's really been sort of a short-lived regime. And I think we're working with a number of schools to implement new procedures and protocols internally so that they're catching only the right things now under the new rule. And so that reporting changes to the reporting on different events, I think is we're getting a lot of questions. I would say too that been talking with a lot of folks about and this came up, the leases and the long-term debt. I mean, having been on the financial responsibility subcommittee, obviously spent a lot of time there, as you all alluded to. And I think one thing on the leases is, again, it's really important to look at the final rule, because the final rule is different than what the proposed rule had, and it's different than what the subcommittee and the negotiated rulemakers had recommended originally. It's effectively a forbearance on leases that are entered into before December 15th, 2018, so-called pre-implementation leases. And one thing that I've been talking with folks recently about is, even if you don't think that pre-implementation lease is going to have a materially adverse impact on your composite score this year, or when it first affects you, because as a private institution, actually because FASB delayed the implementation date, you won't be impacted by these accounting changes now for another another year or two, depending on your audit cycle. But even if you don't think it's going to hit you in that first year that the FASB gap changes apply to the composite score for you based on your status, I think it's really important to take the opportunity with the supplemental schedule to indicate those pre-implementation lease amounts. Because if you don't do it, then the department in future years during the period of time where you may still have those leases might think you waived that right to consider them pre-implementation leases, because there is that possibility. So I think I've been talking with a number of accountants who are starting to look at the supplemental schedule and say, even if you don't think your leases, once the gap rules, the new gap rules apply to you, will have a materially adverse impact on your composite score, put it on the supplemental schedule anyway. Ask for the forbearance anyway, because once you waive it, it's gone. And you can't then come back a couple of years later and say, oh, this lease that was entered into back in 2018 is now impacting my composite score such that I fail, even though it wasn't before. You want to take advantage of this exclusion from the moment that it's available. The other conversations, I think, long-term debt. I mean, this new treatment about long-term debt, in talking with not the accounting firms about this, folks that we all work with about, this is effectively going back to 2002, 2003, and having to justify what you include in long-term debt with capitalized assets in the supplemental schedule footnotes or in the footnotes to your financial statements. And so that's going to be, I think, a big change for folks as they think about, what debt is used for and how people have applied debt in the past to the composite score. But on that, it gets really weedy on the accounting side. So I'll defer to Chris on some of the CPA issues in particular.
Well, I'll jump in and follow up, Jonathan. Thank you. Related to the long-term debt, so and I've gotten a lot of questions about that because, the key point now with the regulations is that any debt in the future, if you want to include that long-term debt in the composite score calculation, you have to be able to demonstrate that you use that debt to acquire property, plant, and equipment. So it's got to be tied to that. The footnotes have to indicate that the debt is related to that acquisition, and that has a material impact. And so it gets into discussions about, when you're planning right now. I mean, what the debt that you've got, there's, as far as, well, what there's a grandfathering provision of pre-implementation debt. So then that begs the question of, well, what is pre-implementation debt? Well, that's the debt that was reported on the last financial statement that you submitted to the department prior to July 1 of 2020. So for most schools, that number's baked in. You've already submitted your last financial statement before July 1 of 2020. That's 13, 14 days from now. So that's your pre-implementation debt. That number can only go down, and then it raises questions of, well, what if I refinance that debt? What if that debt was a 10-year amortization schedule but a 4-year repayment term with so there's a balloon payment at the end? How do I treat that? Now, the department in April did come out with some information and additional a Q&A to address some of those issues, to give you some protection that if you do refinance an existing debt, so long as you're not adding anything to it, as long as you're keeping it to that amount. If you have a balloon payment that you need to refinance, again, if you're not adding anything new to that, you're just refinancing that piece of it. So there is some guidance and some comfort for those things, but those are big issues. And then certainly going forward, if you're looking at taking debt on for any reason, whether it's operational debt, whether you are looking to buy new equipment, whether you're looking to finance an acquisition, understanding how that's going to impact your composite score in the future, making sure you're aware of that. I mean, again, it's not something we don't want the tail wagging the dog here, but you need to be aware of those issues and how it's going to impact your composite score, so you don't have an unexpected situation coming up in the future. And that's one of the things I kind of like to tag on to along with the leases is, even though we did, as Jonathan mentioned, the effective date got pushed back another year. So it's really not going to affect schools until 2023. I think it's for fiscal years that start after December 15th of 2022. So we've got a little time before the gap rules apply, but it applies to any lease that, for composite score purposes, it applies to any lease that is entered into on or after December 15 of 2018. So you've got these leases that you might be signing now or in the future that, they don't have an immediate effect, but they're going to have an effect. And so again, understanding what those implications are if you're negotiating for a new lease, again, just so that you're prepared for when you have to implement these rules, understanding how that's going to affect your composite score.
Dennis, Aaron, Roger? Aaron, we're having a little bit of problem hearing you.
You're cutting in and out, Aaron.
How's that? Is that better?
Much better.
There you go. All right. So I'll offer just a couple of thoughts. In my mind, there's so much happening right now, both with regard to, all the things that go into effect July 1 that we're focused on here. And then, of course, there's COVID and the CARES Act and Title IX and all these other things. It is no doubt overwhelming. I'll suggest that it's probably overwhelming for a lot of the folks that you can see right now. Certainly we are. It just seems like drinking from the fire hose all the time. So it seems like, in my mind, one of the critical exercises here is prioritization and trying to understand what are really the things that you need to do by July 1 and what are the things you can think about a little bit later. Even though the long-term lease and long-term debt concepts, in theory, we were just saying are going to affect fiscal years in the future, I do think those are incredibly important. And so I would suggest that folks put that at the top of their list and talk to their accountants, lawyers, whoever, very soon to make sure they understand and think through how those changes are going to impact their financial situation. The arbitration agreements for certain is something that folks are thinking about right now and taking steps to modify, and that makes sense. And hopefully won't take too long, get with your attorney or your advisor, whoever that might be, and make those changes. I also just wanted to add, as you are changing arbitration agreements, as you are changing, your internal protocols for what you have to report to the department, whether it be under financial responsibility, the new requirements or otherwise, keep in mind that you want to keep a record and documentation sufficient to show a regulator that you made the disclosures that were required prior to July 1. Right. So even though things change as of July 1 and you're going to have a new arbitration agreement potentially, or you're going to have a new set of reporting requirements, you could still be audited a year from now by the department or other parties, and they might audit your compliance with the rules that were in place prior to this July 1. So it's great to do the things you're supposed to do, but when it comes to an audit, you need to be able to document that you did the things that you do. So as you're transitioning and making all these changes, just make sure to keep documentation, keep those old enrollment agreements, the old arbitration clauses, proof that the emails that went out contained the right stuff, that the direct disclosures that had to be made were made. That should be part of this exercise, is making sure you can sort of put that time capsule together and show someone in the future that you did everything you were supposed to do. I do think that getting your mind around what needs to be reported to the department on a go forward basis under the financial responsibility changes is important. And, we've got a little guide. I know others have put things out, but somewhere you need to have that available and make sure you're getting the right people in your organization together. And you're saying, okay, who's monitoring this stuff? We're all clear on what has to be done on a go forward basis. We've got our little cheat sheet, and we know who's going to be responsible and keeping up with certain things. I think at a high level, those are the things that are most important in my mind. The bar defense claim process is not going away. Of course, that was a huge part of this negotiated rulemaking. But my great hope is that for 99% of the people on this call right now, you don't have to think about that come July 1st, and maybe never, I hope for you. But if you do, it's likely going to be down the road. And when that happens, you can call your attorney and figure out what you need to be doing next. I think that's it for now, and I'll toss it over to Roger. Mr. Swartzwelder.
Thank you, Aaron. Well, there's not a lot that I can add to the intelligence that you just heard from my colleagues here. The one thing I would suggest is, like everyone else on the panel, we are spending time with clients getting arbitration agreements and class action waivers in place. And the one thing I would suggest to you is that even if there is some reason why you decide that you don't want to put an arbitration agreement in place, I think it's worthwhile to consider a class action waiver at a minimum. As schools are, reopening this fall, you're going to have potentially, people getting sick or something that could happen, and a class action waiver may be able to help you deal with those issues on a one-by-one basis rather than in a collective manner, and that is something that is worth considering. I would expect that most of my colleagues would agree that for most schools. I believe an arbitration agreement makes sense, but even if you decide for one reason or another not to do that, I think you should consider the class action waiver as a viable protection for the school going forward.
Yeah, I'll just add for folks might be interested, but we had for the first time in the last couple, 3 weeks, 2 clients in the private nonprofit side of the house, traditional institutions, reach out to us and say, we want to talk about a class action waiver. And they're both being sued, over to not having refunded tuition and fees and things like that. So it's interesting that you may have more institutions in traditional higher ed seriously considering how they could implement those types of provisions as well.
Yeah, I don't want to take away from others, but I've had that conversation as well with private nonprofits and the litigators in our firm who are defending some of those cases. Well, why didn't they have arbitration clauses? Why didn't they have class? And well, this is why, because of what the department did the last couple of years, and people are looking at that again.
Agreed.
Yeah, and I think
Dennis, I'll let you back clean up, and then I've got 3 questions from our participants. So go ahead and share, Dennis, and then let me ask a series of questions of you all.
Sure. I mean, I think a couple of related points. I mean, first, one of the nice changes, again, with all these other things, we kind of forget the borrower defense claims, which is, arguably the most important part of this. One of the big changes is we've lost the breach of the clause of action, which I think is really, really helpful as we move to open up. All the claims that we have now, all these student refund class actions, they're all breach of contract or some variant of, they aren't really misrepresentation, which is what the bar defense claims are going forward. So I think that's really helpful. Another thing that's actually, to pick up, I think, Aaron, you had mentioned about some claims. The department is processing claims. I have a number of clients, sadly, that have these claims, and we are going through the bar defense group has sent out emails, and it's ED school evidence at ed.gov. If you get one of these emails, what they're asking for is, does the school have any evidence that they can put forward with regard to these claims so they can evaluate what's going on? You have about 30 days for them. Importantly, you will get the actual claim, right? You'll get kind of a prefatory letter saying, hey, we've got a bunch of these claims, it's general topics, and then you will get each individual claim, so you get to look at that. Very important, be attentive on that. You want to make sure you get your evidence in there. You want to make sure, as depending on the dates involved, some of the ones that I've got, and I would presume many of the ones that are going to be coming out now are older. So let's not forget the standards changed. Anything prior to July 1, 2017, and we'll put aside the litigation and the effect of it at the moment, anything before that was based on the acts or omissions of a school. Does it create a claim under state law? So if you've got someone that can represent you and instruct the department on what that state law is, why this does not constitute a cause of action, there's some retirement or something, I think that's really smart. I think it's a really smart way to try to get your views out in front, as well as providing the evidence. Also, as you're looking through that, the department in December came out with its methodology for partial discharge. Look at that methodology. Essentially, it's based on a comparison of your graduates' salaries after graduation compared to the median salary of like institutions as all reported on the college scorecard. Lots of unanswered questions there. There are going to be some programs that aren't listed. There will be some entire schools that aren't listed because of the timing of the scorecard. A lot of the upper tier programs, degree programs aren't listed. But make sure you are aware of all of that and can advocate effectively as you respond to the department.
Thank you, Dennis. The first of a couple of questions from our participants. If a school uses the department's website for entrance counseling, how is it recommended that the new requirement for internal dispute and/or arbitration be disclosed?
On your webpage, wherever you have information about admissions. If you have a tab on the top of your webpage, it says admissions or learn more or whatever is sort of the directional page, you'll want to have information on there that is easily accessible in 12-point font, I repeat, that indicates that you use a pre-dispute arbitration agreement and a class action waiver or whatever it is that you use, and you just have to give a layman's explanation of what that means. It doesn't have to be the actual agreement. It has to be an explanation of the fact that you use this and what it means. And then you would use your whatever your standard agreement is as part of your enrollment process. So if you're using the department's entrance counseling, and I presume they're not going to have anything in there because they won't assume you're using an arbitration provision, then you just need to make sure you have this information publicly available.
Thank you, Kate. Next question. If you amend a lease that was executed prior to the 12/15/18 grandfather date to change some terms, but leave the executed date that was in place prior to 12/15/18, will that amendment impact the ability to exclude the lease from the composite score?
That's a good question. The guidance, the frequently asked questions that the department issued gets into things like if you exercise an option, if there's a change of ownership, and so there's new owner. So even though the lease stays the same, there's a change of ownership. That's a new lease. So that would no longer be grandfathered. That's something where if the terms aren't changed, if it's the payment terms, the length of the terms, I think, I don't have a specific answer because I don't think that question was addressed by the department. So I think it would probably be like, how much of an amendment are we talking about here? I mean, if we're amending like notice provisions, I don't think that would be a new lease. But I think it would depend on the nature of the amendment to figure out whether or not that's material enough such that it would be treated as a new lease.
Yeah, I would agree with
thoughts are on that.
Yeah, I would agree with you. The department's been a little cagey in terms of committing on that question because we've asked about amendments and waivers and things like that, and they've answered, as you said, with respect to changes of ownership. And I think the change of ownership standard is an interesting one because why they're saying a change of ownership basically makes a pre-implementation lease a post-implementation lease, even if the lease didn't change, is because there's been an intervening business decision regarding the school. And so I think to your point about the materiality, is this a minor technical amendment or a technical update to the lease, or are there some real new sort of material changes to the business relationship between the lessee and the lessor? And the more significant of a business change it is, or more significant of a business decision it reflects, I think that that the more likely it is it will no longer be excluded. I mean, this is something where, fortunately for privately held companies anyway, the extension of the FASB implementation date gives us some more time to try to get the department, once we get past all the immediate urgencies, to go back and revisit that question.
And I'm just going to guess. I don't know if this is where the question's coming from, but I know because I've worked with a number of schools that have had modifications in their rental payment terms. So, for example, maybe they renegotiated with their landlord to have March and April rent forgiven. So that would be an amendment. And so that may be where this is coming from. And I think that would be certainly worth following up with the department, I think, for questions like that, because it would seem to me if it's the same rent term, but there's an amendment to provide some sort of rent relief due to COVID-19. I'd argue that that's not a material change to the term, and that shouldn't create a conversion from pre to post implementation. But it also seems like that's something that if that's where the question's coming from, that's a reasonable request for further guidance from the department.
Shifting gears a little bit, and Aaron, I'm going to lob this one to you, but others can chime in after you because of your conversations a little bit earlier with regard to the same topic. Would you recommend making arbitration agreement changes, even if it's possible that they could be reversed in the election in November, and then potentially have the change revert back in subsequent years? Kind of a political question, kind of an 8-ball question, but.
Yeah, sure. Well, I think the initial question you have to ask yourself as an institution is whether you want to have an arbitration clause at all. And I don't mean that. That's not a throwaway comment. I mean, there is, I think most attorney types, defense attorneys, at the end of the day, like the idea of an arbitration clause. It's not a foregone conclusion, though. I mean, there are some institutions that don't companies, I mean, inside and outside of higher ed, that choose not to have pre-dispute arbitration clauses for various reasons. They sometimes have done the math and don't even think that they're helping them out. Class action waiver is a separate consideration. I mean, they tend to get lumped together. But I think the first thing you have to ask yourself is, and check with your counsel and think through it and say, at the end of the day, is this something we think we should have? And if the answer that you arrive at is yes, then I think you ought to put it in for every day of the week that you can include it, right? I mean, if there's a change in the political winds in November and we see a new rule. By the way, something else I'll note is, this is a regulation. So let me take a couple of steps back. First of all, I think you should put it in if you believe that it should be there, right? If you think for legal, philosophical, whatever reasons it should be there, pre-dispute arbitration clause and a class action waiver, then you should have them in the agreement, right? Even if you see the Democrats take the House and the White House and the Senate and hold the House in November, keep in mind that the changes being made right now are being made in law. These are regulatory changes. This isn't sub-regulatory guidance. So even if a subsequent administration wanted to move in a different direction with regard to arbitration clauses, I mean, I'm not saying they couldn't try to accomplish anything through executive order or enforcement actions, et cetera. But at the end of the day, if they want to change the existing regulation, they're going to have to go through a rulemaking, and that's going to take a lot of time. So even if they decide to do that, you could still see months, likely years, where your pre-dispute arbitration clause and class action waiver would remain in your enrollment agreement, which you've decided should be there. And every day that it's there, it has value, because you've got people coming in every start, they're signing new enrollment agreements, and that means that those concepts are going to be there in the event that those individuals try to bring an action against the institution. So if you think those clauses have merit, then I would include them for as long as you are allowed legally to include them. And I would not be concerned that a change in the political winds in November would overnight result in a change in the law. I think that even with the most aggressive approach from the department or from a subsequent administration, even if they tried to use the Congressional Review Act or something like that to kill this regulation, on a go-forward basis, it's going to take time. And every day you've got those clauses in there, they're giving you that protection that you've decided has value.
Right. Yeah, I mean, July 1, 2023 would be likely the earliest that a new regulation could possibly take effect if there is a change in administration. So I think Aaron's counsel is smart.
One or two more before we shift on to accreditation and state authorization. For an institution which hasn't adopted the lease standard, no right to use asset or lease liability will be included on the balance sheet. Thus, what would the institution enter in the supplemental schedule for its pre-implementation lease amounts? The right to use assets and lease liability are probably not yet computed. You can tell this was an accountant question.
Yeah, and it may be a response to, I'll not to monopolize the topic, but I think it may be a response to what I was suggesting. I think, while as if you're a privately held company and you have no public debt, the FASB standards now won't be impacting you until, I think as Chris was saying, I think it's 2023, right? It's after December 2022. I think in terms of the supplemental schedule today, there's nothing to include. But in that first year that the new GAAP rules and new FASB rules apply to you, and they will apply to you regardless of whether or not you want them to, you should indicate that if you still have pre-implementation leases, you should indicate them on your supplemental schedule in the very first year that you're subject to the new accounting rules, was the suggestion.
Anything to add, Chris?
No, I agree.
Okay, thought so. I just wanted to make sure. One more on supplemental schedules before we move on. Will supplemental schedules for financial responsibility be required for any financial statements submitted on or after 7/1/20, regardless of the year end, or does this apply to financial statements for year ends ending on or after 7/1/20?
So, I mean, after 7/1/20, you're going to have to indicate your pre and post implementation debt, if nothing else. So you're going to have that, those disclosures. If you want existing, you want to be able to demonstrate you've got debt from the last financial statement you submitted before July 1 of 2020, and you want to continue to treat that as long-term debt and include that in the composite score calculation, you're going to have to make that that distinction. And so I would think, I mean, again, not being an active CPA, but I mean, I don't see how else you're going to be able to take advantage of any existing debt you have without using the supplemental schedule.
I'd say also keep in mind the supplemental schedule, even though we talk about it here primarily with respect to the lease accounting changes and the long-term debt, it also involves the composite score itself. The actual origination of the supplemental schedule conceptually in the committee was to create a place where the composite score elements would all be pulled out of the balance sheet, out of the footnotes, et cetera, into a place that was all in one spot, because nonprofit financial statement on their face will no longer have all the elements right there, and there's some changes to nonprofit financial statement presentation rules. So the idea of the supplemental schedule was, let's tease out of the various notes and lines in the financial statement all of the elements of the composite score. So that's actually the primary purpose for the supplemental schedule, is to have all that in one place, such that if there's a dispute between the school and department, you can actually more readily get to the particular number that's in dispute. The lease issue and the long-term debt are sort of additional benefits that you can use the supplemental schedule if you'd wish. So you'll have to do the supplemental schedule even if you have no lease or long-term debt concerns.
One last one, and then we'll move on. Are gag clauses permitted? Should they be added to arbitration and class action waivers?
What clauses?
Yeah,
Gag?
I was gonna say, gag?
It says, yeah, GAG. Are gag clauses permitted? Should they be added to arbitration and class action waivers? That's the direct question.
Maybe like a non-disclosure agreement? Is that what they're thinking of?
I think so.
Let me see if that person will add to their question real quick.
Hey,
And if
Tom,
oh, go ahead. Sorry.
go ahead. Well, I was just actually, while you're looking at that, I had another comment. I wanted to just highlight something Kate said earlier, which I thought was a really important note. And in some of my conversations with my clients, I'm not sure has been fully appreciated. And that is this distinction between what the department is requiring on a go-forward basis, which is sort of a plain language disclosure, and the actual disclosure of the agreement itself. So I've had a number of clients that I've chatted with who I think are under the impression that, and you know, in part you are modifying your existing pre-dispute arbitration agreement. You're taking out those clauses that were required prior to July 1 to the actual agreement. But then there's this notion that on a go-forward basis, the plain language disclosure is supposed to be the agreement itself. So you're supposed to provide the agreement in all these places that they say the plain language disclosure is supposed to be supplied. Unfortunately, the regulatory language I don't think is crystal clear on this point, but the commentary in the preamble to me seems to pretty strongly suggest what Kate said, which is the department isn't expecting you to actually post the entire pre-dispute arbitration agreement that's in your enrollment agreement or wherever in all these various places. What they really want is something that's simple and clear and sort of practical, and apart from the agreement itself. So that's something you should talk with your counsel about. But you know, you may not need to post the entire agreement in all those places. What you really, I think the department's expecting you to do is to have something much simpler and plainer and easier to understand. The other thing I want to highlight is there is some specific language that's supposed to be included in that plain language disclosure. So as Kate mentioned, you know, there's a little bit around what is, you know, 12-point font and that kind of stuff. But there are 2 or 3 lines if you're using a pre-dispute arbitration agreement post July 1, wherever you're making that plain language disclosure, there's a little bit of new canned language that you're supposed to include with that plain language disclosure as well. So as you're thinking through this, I think the point is you talk to your counsel and figure out whether you really want to do the whole agreement or you want to just have a sort of separate, simplified, plain language concept that you're putting up there, and make sure it's got that little bit of requisite language in it as well.
Okay. The follow-up from our previous question, gag clauses. These provisions prohibit student or former students from telling other people about the complaint resolution process or about the specifics of any final ruling. These types of agreements have long been common in settlements of disputes, but they are now appearing in contracts and other documents that colleges require students to sign as a condition of enrollment before a dispute even arises.
I haven't seen that in the actual agreement. I mean, in plenty of situations during an arbitration or in the conclusion of an arbitration, when you're signing a settlement, there'll often be language in the settlement agreement about it being confidential. But I would defer to the rest of, I can actually say the guys, on whether or not they're seeing that in the actual arbitration, like that's what you're signing pre-dispute. I haven't seen that as something in the initial agreement.
Yeah, I'm kind of in the same place. I'll just add though that there are, what I have seen are state laws and policies elsewhere that prohibit institutions from trying to put some sort of gag order or pre-complaint gag concept in place for allegations of sexual misconduct and other kinds of discrimination against protected classes. So if you decide to go that route where you're going to have students sign something pre-complaint, where they're going to agree to give up their rights to talk about that complaint, I would be very careful to exclude or at least be mindful about whether or not you're trying to cover complaints that might involve protected class type misconduct, like, you know, sexual misconduct or racial misconduct or something like that.
Well, and also I think that ties into, Aaron, that, you know, what you're talking about, the language that has to go in that plain language disclosure. What that language is you have to tell students that they're not prohibited from filing a borrower defense claim.
Yeah, right.
Well, I mean, that's basically what it gets to, is that, you know, they still have the right, and you have to tell them they still have the right to file a borrower defense claim, even though they've signed an arbitration. And the preamble to the regulations and the description about that also talks about the fact that there's borrower defense, but there's nothing to stop students from filing complaints with crediting agencies and state agencies. And so that gets to as well, you know, I think, you know, trying to prohibit students from, you know, using those courses of action, I think would be problematic.
Agreed.
Well, thank you one and all. We're going to move on to accreditation and state authorization. Just a quick recap on my part, and then another series of questions around these very heady topics as well. I want to stop here and say thank you guys yet again. A wonderful facilitation of conversations around the first set of issues. I learned a lot, and I'm sure others did, from the responses I'm getting back. And thanks already for all of what you all are sharing with us. So moving on to accreditation and state authorization. Again, this particular final rule came out on November 1st. The exact deadline for anything to be implemented under the master calendar in the subsequent year on July 1st. And it had a great deal of change to it as well. We're going to cover both the accreditation and state authorization and a number of disclosures in those areas and additional disclosures that were required as a result of this regulation. We'll start with the accreditation side. As I think many of you are well aware, the regulations and the negotiations, which were actually ended up in a consensus by the group, provided a great deal of new flexibility to the accrediting bodies, made a significant number of changes that would provide for distinctions in the way in which different types of institution within their oversight were reviewed, a lot more bandwidth and elasticity around their accreditation standards and how they could do the standards themselves, and a great deal of additional autonomy for the accreditors in terms of the flexibility around, in particular, distance education, which ties into the state authorization stuff that we'll talk about here in a few minutes. At the same time, the Secretary's oversight and authority was modified as well in terms of the recognition of the focus on the accrediting agencies, which literally has kind of led to a blending or a blurring of the lines in many respects of regional versus national accreditation. Given a number of the changes that were included in this package, the department really doesn't look at regional and national accreditors the same way they did prior to these regulations. It's kind of more of a group of all as opposed to the distinguishing categories. There were also a number of changes in the actual oversight by NACICI, the National Advisory Committee on Institutional Quality and Integrity, with regard to the process of how the accreditors themselves are viewed and overseen by the department and NACICI as part of their recognition process. The accreditors oversee you as institutions, NACICI and the department oversee the accreditors, and so there were changes into that process. Again, also modifications on the overall view of the triad, and an attempt by this package of regulations and this department and these negotiations to drill down more and to make more clear and distinguish the lines of what the responsibilities of the department versus accreditors versus the states were, giving direction and to a certain degree through definitions as well as changes in the regulation, better directives of who was responsible for what. Another major area was with regard to teach out requirements and the roles and responsibilities of institutions and the accreditors with regard to teach out processes, approvals, and agreements that are all part of this regulatory package. Shifting now to the state authorization side, the key changes here included a number of revisions to state requirements versus reciprocity agreements under institutions that have distance education and online, a distinction clearly made between the differentiation of having to comply with each individual state's requirements or the ability, if you adopted the SAR and the state reciprocity agreement, the SARA agreements, that you would then be able to utilize that in lieu of having to comport and comply with each individual state. The distinctions that were made between student location versus students' residence, and the fact that it is where they currently reside, not where their home address might be, that is important for the purposes of determining and establishing those requirements for a student under distance education and correspondence. A key area is the disclosure with regard to programs leading to licensure and certification, and the requirement that additional information be included as part of the institutions, by institutions with regard to programs that lead to licensure and certification. You can see on this slide that it talks about all of the curriculum meets the educational requirements for licensure and certification in of all the states that they're participants in, the list of all the states that the curriculum does not meet those standards, and also a list of whether or not an institution has not been able to make a determination of whether or not those educational requirements are met. This was a big portion of the negotiations throughout those negotiations, as was the direct disclosure to prospective students if and when it is determined that a program does not meet those state educational requirements. There was a great deal of discussion throughout those negotiations around these points. In addition, there were a number of institutional disclosures that were added. Some of these, I think, are going to make significant changes for overall communities and overall enlightenment and force new dialogues with a number of our companions and compatriots in traditional higher education, not the least of which is because of the changes with regard to transfer of credit policies and the need to post those as part of an institution's information, graduate and placement, other outcomes, as well as pending things happening with the institution. Breaking this down even further into the clearer nitty-gritty, with regard to transfer of credit, there must be a publication of the description of each institution's transfer of credit policy, and it has to include any established criteria that the institution uses regarding transfer of credits, the list of institutions with which the institution has established articulation agreements, and the written criteria used to evaluate and award credits for prior learning experience based on the submission by individuals seeking transfer of credits into the receiving institution. By forcing the hand of institutions, I think in particular, to provide this written criteria, to say nothing of the lists and the establishment of the criterion that must be used, it doesn't prohibit or preclude institutions from still utilizing a lot of their limitations or prohibitions, but it certainly forces them to make them openly viewable to the public, and then have the individuals in the public asking the questions of that receiving institution more so than the prior institution as to why all of my hard work and what I did at the prior institution is not eligible for at least consideration as part of transferring into the new institution. So I think that that is a significant sea change in a lot of the way in which transfer credit policies may be looked upon and may be utilized going into the future. In addition, institutional arrangement disclosures, because of a lot of the linkages between institutions with regard to the providing of education around distance education in particular. There are certain requirements of the arrangements that institutions have between one another that need to be provided, and this is the list of those 4 per criterion. Demographic and outcomes information, once again, is another major set of disclosures. The percentage of those students enrolled on full-time students with regard to whether or not male or female, eligibility, and self-identified as a member of different racial or ethnic groups, placement rates and retention rates. So this gets to, as I said, social demographics, as well as true outcomes measures. We then have health and safety disclosure requirements, the reporting of the fire safety report prepared by the institution annually, as well as their vaccination policies, and then a series of administrative policies that also have to be provided by all institutions, including ones that we're all familiar with, refund policies, but also who to contact with regard to the filing of a complaint with the institution's accreditor or the state, and if required, whether the institution is required to maintain a teach-out plan by its accreditor and the reasons for such. So a significant number of these, and last but not least, if their institution has had enforcement actions, they have to share that as well. A long-winded way of saying, in a very quick set of circumstances in the course of the review, that we have a lot of new disclosures that truly do go into effect July 1st, that I think, and back to one of Aaron's comments, as you're looking at priorities, I think that needs to be high on the priority list. And I'm not an attorney, and I didn't say in a Holiday Inn last night, but I truly think that should be high on the list of priorities, because I think the department and others are going to be looking for it come July 1st. But a lot of information there to discuss and talk about. So I will open it up to the group, and I will go in reverse order this time. No disrespect, Kate, but Dennis, since you were the last to go at the beginning, I'm going to let you lead off this time in the discussion around accreditation, as well as state authorization and the disclosure issues, and then certainly look to all of the panelists for additional discussion.
Sure. Well, thanks. And I think, the disclosures the disclosures, I think the department tried to make them as manageable as they could be. I mean, they are an improvement on some of the disclosures that were originally proposed and published by the Obama administration. In particular, I think the one on the state licensure is a key one, because I think the department tried to make it as palatable as possible, right? Again, and here, just recall, you've got to say whether or not your program leads to licensure in a given state, or if it does not lead to licensure, or if you just haven't made a determination. And I think that that's useful, because unless your program is national in scope, right, that's a fairly manageable standard here. Again, for some programs, it becomes very problematic because you're marketing to an entire, into the entire United States. Some of the nonprofit programs at large universities, they're the ones that are having some difficulty, because now they've got to learn what the licensure standards for that program are in other states. But I think it makes it much more manageable than the original one, which, as I recall, the Obama administration had, was that you had to list every state within your metropolitan statistical area, which was every contiguous state, which, again, I'm in New York, and it seems very far-fetched to me that a trade school in Syracuse that teaches a licensed program, that many of those students are going to be going to Pennsylvania or Vermont or any of these states, much less anywhere else. You're staying where you live. So I think that is very helpful. On the, some of the changes on the accreditation, I mean, the disclosure of transfer credit, I think, is really useful. But one of the things that we're seeing, and I'm curious what everyone else is, now that the department has done away with regional accreditation, the regional accreditors seem to be fairly willing to go into other people's regions, and that's coming into play in a number of transactions that I have, where you've got, school X in one place and it has one regional accreditor or one accreditor, and now the school that was accredited by a different accreditor is saying, hey, we're here, we're happy to stay with this accreditor, and we'll happily move into this or that jurisdiction. So I think that's another interesting piece of regulations. But yeah, so I think those are the things. And I think you're right about the transfer of credit. I think that's really going to be important. I mean, there have been too many stories of military men and women who have gotten degrees from nationally accredited schools that were then just disregarded when they went on to try to get their master's or an advanced degree. And hopefully some schools will be shamed into doing the right thing there. Kate's laughing because no one gets shamed at all.
Again, going in reverse order, Roger, anything to add or any observations? What are your hot buttons with regard to this regulatory package?
Well, I think, as you said earlier, there's a lot here. There's a lot for schools to be paying attention to, lots of details that need to be managed. But I, like Dennis, would focus on the professional certification and licensure question. That is one that I think, I may disagree a little bit with Dennis here in that, I think that a school has an obligation, certainly as a matter of, protecting itself, to make sure that it is looked at states across the country with regard to how its programs do or do not satisfy the educational requirements. The last thing that you want to have is a student who relocates across the country and suddenly can't use his or her degree for an occupation in a state where that the student wasn't originally located. And I think one of the things that schools should keep in mind is that in some occupational areas, it's clear that professional licensure or certification is required universally. I mean, think of, accounting, it's licensed virtually everywhere, for example. But there are a number of occupational areas that are regulated in some states, but not in others. And I think that is something that lots of schools should be paying attention to, thinking about something like, massage therapy is an occupational field that I don't know what the number is exactly, but let's say half of the states regulate it, half don't. And to the extent that there are states where it is regulated, you're going to want to make sure either that your program complies with those requirements or that you've at least listed on your webpage those states and indicated that you have not had an opportunity to make that determination. I think that is something that would do schools a lot of good to pay closer attention to.
Aaron, next up.
Yeah, I'll offer a couple of general thoughts. I mean, the first is, Tom, I was really pleased to see that you went beyond just the licensure and certification disclosures, because in the context of even in the prior iteration of this rule in 2016, it was distance education focused, and while licensure and certification was part of it, it was still all about distance ed programs. And what this rule and this administration really done is they've taken a step back and they've said, we're taking certain elements, we're dropping them in to the consumer information framework that already existed, and we're also making other changes. So we're taking the professional certification items over, but then we're looking at these other things like transferability of credit and the fire safety report, the vaccine disclosure, et cetera. And I think it's really important that listeners understand that and appreciate that this isn't just about distance education programs. In fact, it's not at all. We're talking about all programs, and it's not just about certification, professional licensure. We're talking about a number of changes and revisions to the general consumer information framework. The other thing I want to encourage folks to do, I know you're dealing with COVID-19, you're dealing with the CARES Act, you're dealing with Title IX, et cetera. So I'm not suggesting that you do what I'm about to suggest overnight, but I would say come this fall, you should put together a working group at your institution and take a step back and say, there have been a lot of changes to the consumer information framework overall, and the types of things that we have to make available on websites and the types of things we have to directly disclose to students. Many of them wrapped up in these July 1 regulations that are going into place, but outside of that as well, right? I mean, in other areas, and some of that is at the federal level, some of that's at the state level. I often find that my clients have forgotten about a lot of the other consumer information requirements that have been around for years and years in 68, 41, and 42 and 43. So I encourage folks to sort of take a step back with all the changes that are occurring and think about, are we sort of hitting on all cylinders, or at least most of our cylinders, These consumer information requirements. Do we have a master disclosure we make every year that all of our students, it tells where everything is? Do we have Clery Act, and if it's applicable, the fire report in place? You know, I would take a broader view of all of this and revisit a lot of it, because there's a lot that tends to slip through the cracks, and there are a number of changes that are being made. So I think it's a worthy exercise.
And continuing in reverse order, Jonathan next, and then Chris. Or Chris
Well,
and then Jonathan, I forget who went in what order.
I would agree with everything Aaron just said. I would note, I don't want to be necessarily a downer. Many of these disclosures are actually things that are not actually new. Many of these disclosures, or the fire safety report being one that comes to mind because it seems so out of left field, have been in the HEA for many, many years. And actually, occasionally you would see program review findings around these things where they weren't able to cite a regulation, but they would cite the statute. And I actually got the fire safety reports one. I actually had a program review finding once with a client on that, and it was resolvable. So many of these things aren't actually brand new. They're just new to the CFR, and the department's putting them into 66843 and other places, so they have an easier hook in terms of FSA looking at these issues than having to go back and see what it's in the law but not in the regulations. So hopefully, hopefully many institutions, probably not all, some of these things are not going to be brand new, and you're going to be able to just modify how you do it. I do think having a single catalog, a place in your catalog where all of this is presented, or a single consumer information packet where all this is presented, is really useful. It just makes, it provides consistency, and it's also just easier to manage from a student perspective. A couple things on the state authorization side, and again, I would agree, I think, with Roger on this, in terms of, while the regulation provides that you can sort of take a I don't know what the professional certification rules are in a particular state approach, I think that has a lot of risk, because lo and behold, somebody will file some suit or some claim, and there'll be somebody in the organization that knew what the rules were, somebody in the program that knew. And the institution, it makes it harder for you to say that the institution did not know, did not make an assessment of somebody in the program, whether it be a program chair or a vice chair or somebody else. So I do tend to think that, the better thing to do is to do the 50 state survey and have it kept up to date, and just have, it's an administrative task for sure, but I think that is just, at the end of the day, preferable over not knowing, and ignorance, while permitted here, is a bit more risky. The other thing I'll say, which everybody on this call should know, but it came up recently with a client who's a private equity owner, not a school operator, so I'll give that caveat. Remember that SARA is institutional in nature. It's not programmatic in any regard. And I raise that because I think there are going to be a number of institutions who are going to have composite score challenges this year. And regardless of what the department does on any composite score relief, SARA has a composite score standard. And if your composite score drops below a 1.0, you could be out of SARA. And so I would, and I've had some clients who are looking at that possibility, actually more on the private nonprofit side, because of issues where they've been struggling anyway, where they're thinking, oh my gosh, we just spent all this time over the last few years to take advantage of SARA. Our composite score may not meet the SARA standard come year end. Think now about whether or not you might have to begin seeking authorization again in a number of states if your composite score, because I've not heard, maybe somebody else in the panel has heard, I haven't heard SARA talk at all about what they'll do with the number of institutions that may have composite score challenges, given what's going on in the broader economy and what's going on with higher education this year in particular. So plan ahead in terms of SARA. If you're in SARA now, know that it can go away if your composite score degrades, and you should be thinking about what this year looks like, and thinking about where you might have to go back and get authorized unless SARA provides some relief. And again, it's institutional in nature only, of course.
Going from there to Chris.
So I'll follow up a little bit on what Aaron said about the consumer information disclosures. And again, the idea of, at some point after digesting everything from, we're all drinking from the fire hose right now, but there's a lot of changes from a disclosure standpoint. And we've talked about a number of them just today, as far as disclosures on websites and catalogs related to arbitration agreements and class action waivers, disclosures with the new state authorization and accreditation regulations. I know we're not talking about this today because it's not effective until August 14th, but we've got Title IX regulations, and there are certain website disclosures for that, changes to your catalog with that as well. And so, again, at some point, taking a deep breath and making sure you've got everything covered. And the idea of having an annual consumer information disclosure statement, I mean, that's something you should be doing already. That spells out, okay, here's all of our consumer information, and here's where you find it. It's here, it's in the catalog, it's on the website, wherever you have that. And that's something that should be updated annually, distributed annually. And it shows, again, it kind of use it as both from a disclosure standpoint, but also use it as an internal checklist to say, okay, here's everything we have. Do we need to update any of this? I mean, some of it you have to update. You have to update your annual security report, your fire safety report, if that's applicable to you. I mean, that's on an annual basis, but just to make sure that you've got everything and are staying on top of it, because over the next 2 months, there is a lot that you're going to have to change, and make sure you've got that all covered.
And last but certainly not least, my lady, Kate.
My lady, come on.
Come on. Well, you're with all the boys, so.
I know, as is generally the case. I won't belabor. I think everybody covered everything. The one thing I will say, as your resident Californian, we're not in SARA. So for all of the schools whose main or headquartered here in California, and I do know of a few that have been considering expanding their distance ed programs outside the state, and doing a little bit more of that. None of the protections of SARA apply to you. So you're going to have to, and by the way, I don't see that changing anytime soon. So I would say be paying special attention to these rules as a California institution, because you don't have the option of relying on SARA for your external state approval. So, to be Captain Buzzkill, California still creates that extra layer of work for everybody.
Yep, California is always that way. A couple of different questions already provided. Does the disclosure for programs leading to professional licensure apply to agencies that are considered, quote, voluntary, unquote, such as the California Massage Therapy Council? Per BPPE, CMAT, the Cosmetology Massage Therapy Council, is not a state agency and consider the CMATC massage certification as voluntary. Therefore, licensure passage rates data from this agency is not required to be reported. Since CMAT does not require graduates to pass the various examination tests or receive the certification to work as a massage therapist, does this new federal regulation apply to the massage therapy programs? Kate, I kind of directed that at you, and that's why I let you go last, because I had this question to come at you first.
So that's an interesting question, and I think that the guys in the panel can weigh in on this one as well, because it's broader than just California. But right. My understanding of the language of the rule is that what you're evaluating is whether or not your program meets the requirements for licensure or certification. And so in California, it is not required by the state that you have certification or licensure to be a massage therapist. But what is interesting in California is, depending on what municipality you are working in, the municipality may have a requirement if you are opening like a massage therapy studio, or the massage therapy studios themselves may have requirements that the municipality has on them that says your massage therapist must have this, even though it's not technically a certification or a license, because that's not what the California Massage Therapy group does. It is one of those things that you need to at least internally be considering. But from the standpoint of this rule, it is not required in the state that you have a license. But it could be like on a sort of sub level, a requirement that you may want to consider disclosing. But I would ask what you guys think. I don't think that this is really what they had in mind, because it's still a voluntary and non-state sanctioned sort of non-license, but that does have some weight depending on where you end up working. It's just that as a school, unless, going back to the sort of 50 state analysis, if you're a school in California and you're training massage therapists, You would literally have to go city by city through the entire state to determine whether or not that city might require that you have this, certification from CMAT, which I don't know that the Department of Ed is expecting you to do.
I think your counsel is smart, though. I don't think voluntary associations are really what we're talking about. Can you do a license exam, or can you present your credential and receive the license, right? And so if you're in a jurisdiction that does not issue a license, I think you can say that. But I also agree that if you know that there are these other rules, you think about it from the situation of a student. The student's coming in, they just know they want to be a massage therapist. For whatever reasons, that's their chosen career. You're not going to know that you've got to have this special certification in Orange County and this special certification in Bakersfield or wherever. So, I think while it may not be a regulatory requirement of this regulation, I think that there is at least an ethical obligation to let them know. And it's actually just smart, because I think what Roger had talked about earlier about whether or not you want to do the 50-state survey. In my example, you want to be, you're doing a license program in Syracuse and no one's leaving Syracuse. You want to make sure they get licensed everywhere. There is some wisdom to letting them know, right? Because you don't want people being unhappy, because unhappy people are the people that sue you. So I think that would make sense. If you know that there are requirements, I would say, here's what we know about these states and, or these municipalities rather. And if you don't know, there may be some other limitations you want to disclose, but more disclosure is definitely better than less.
As a Syracuse native, Dennis, I'm always curious when you start going there. I want to see what you're going to say about my hometown.
It's cold.
It's cold. Actually, not the map behind me is an 1874 aerial map of Syracuse.
Really?
Syracuse proud.
There you go. I just want to add too. I want to remind folks that on the one hand, I think it's really important that schools go through this exercise of deciding whether or not their programs really are covered. It's important to look at the definition of what is considered a program that leads to licensure certification. And certainly part of that definition is if you've got a program that prepares people to go into an occupation for which they have to have some sort of state licensure certification to practice in the profession. But the other big piece of this is, what are you telling people, right? And the regulation also gets at, if in your marketing promotional materials, you're telling people that your program will prepare them for such a license or certification. But this is where I think it gets a little gray, right? So I'll just go the step in saying, if you are telling people, and getting back to this example with the question, if you are making a big deal out of telling people that your program will prepare them or supply the educational requirements so that they can get this CMAT license, even if it's not a clear state license or certification, whether it's required under this particular, I don't want to call it the state authorization regulations, a little misleading, but whether you're required under this regulation we're talking about or not, you can have a bar defense issue, right? If you're telling people you can go through our program, and if you do, you'll be able to get this license and be whatever you want to be in every city in the state, and it turns out that's not true, you got a different kind of problem, whether you're required to make this disclosure or not under this particular regulation. So on the one hand, if you're a distance ed provider, or the example I always use, if you're in Memphis and you've got students, even in your on-ground program, who are coming from Missouri and Arkansas and Tennessee and Mississippi, you should probably be making those disclosures no matter what. But even if you're not required, because if you conclude, well, maybe this isn't a covered licensure certification program, but your reps are telling people that they can get it and it's a big deal and everyone wants it and it's going to give them a big edge when they go out there and try to find a job, I would make the disclosure anyway. I would be conservative about, sort of where you land on some of those things, because a lot of it's about what you're telling people.
Absolutely.
Kind of the converse of that for the panel. Does it make sense to include a statement that X program is not intended to lead to additional licensure or certification, and as such, the institution has not made a determination regarding such in any state or jurisdiction to our catalog or disclosure document as a sort of safety net for non-disclosure, for non-licensure programs? Or do we still need to list out all of the states and what type of, for that type of a disclosure?
I like it. If you're saying we've got a program that we believe is not a licensure certification program, and we're going to include a general statement in our catalog that, you know, unless otherwise specifically stated, programs do not lead to any licensure or certification. We've not made a determination. I mean, you know, you got to workshop the language a little bit so that it's sensible, but I'm an attorney type. I love disclosures. I would not have any issue with that.
I think, though, to your earlier point, Aaron, you've got to be consistent, though. If you're going to make that kind of disclosure, then you've got to make sure that your admissions folks and everybody else is not doing something that undercuts that published statement, because then you got a bigger problem on your hands.
100%.
I think that's right. I think, but one of the things to keep in mind is that, again, the rules in states vary, as everybody knows, and it's important to understand that, you know, a field like surgical technology, for example, not licensed in very many places to my knowledge, but there are some states where you have to be certified to have a CST certification in order to work in that state, and that generally requires programmatic accreditation for your program. So if you happen to be in an unregulated state where you don't need the certification to work, but you know the state next door requires certification, if your program doesn't have that specialized accreditation so that those students are eligible for certification, that absolutely is something that you want to disclose. And it seems to me that the broader, the more inclusive you can make those kinds of disclosures, the better. And so in some of fields like that, I think there is value in listing the 50 states and to say that, you know, we have not made this determination because you haven't figured out whether certification is required in some state that's 4 states over. You want to be able to disclose that so that you have the protection for the graduate who finishes your program and moves a couple of states away and cannot get a job.
Roger, to that point, hold on just a second, guys, just a second, Dennis. Is there any tool or a resource that the schools can use to help them determine whether or not the program meets the licensure requirements in state outside of their own? I mean, is there, or this is because I think I've got several questions of how they go about doing the research to figure this out and if there's any shortcuts.
Outside counsel.
One of the things that
unquestionably the best tool.
I mean, Tom, I think that's the problem. I think with online programs, you're kind of in for the full pound, right? You've just got to do the research. That is what it is, because you're attracting from nationwide audience. Where again, and I keep now I'll know that it's Jonathan's hometown. I'll find your old house and we'll put it up on the screen. I mean, if you are some little business trade program, right, in Syracuse, and Syracuse, I picked Syracuse purposefully because you're going to mistake the next block with another state. You are really far.
No, you've got to drive at least 2.5 to 3 hours to get out of the state. Exactly.
So if I go to that program and I take an accounting program, and let's say I put in, and I think, Tom, if I understood your proposed disclosure, I think it's pretty smart. You said, look, this is going to train you to be a bookkeeper. This is not going to get you a license in New York, right? I mean, I think that's a wise disclosure. And if you want to put in there, and we haven't done the research as to whether or not this program, which provides a BA in accounting, is going to let you be an accountant or sit for the license exam in any other state. And again, because the rules do change all over the place, right? I mean, in New York, you need a master's. In other states, you can sit for the exam. Well, at least it used to be. You could sit for the exam with a bachelor's. I do think that the department provided this flexibility. I think what you had suggested by saying it's guiding you towards a profession that does not need to be licensed. And it's not licensable for bookkeeper. Anybody, I could be a bookkeeper. I don't know if I'm good, but I could be one because I don't need a license. I think that institutions have to make their judgment. I mean, if you want for marketing or legal protection reasons to do that 50-state survey, I mean, I think that's, I don't think that's foolish. I think that it makes a lot of sense. It does provide some real coverage. And as Aaron said, I think any of the six of us can certainly handle that. But I mean, I just think about some of these schools that have a multitude of programs that, you know, it's not really clear if they're licensed at all. They attract from a very local audience. I don't know. I mean, it just seems like that's a lot of expense for them to have to do that. Maybe it's smart. Maybe, I mean, again, if you're covered, if you make the full disclosure, you will not be a licensed accountant in California based on taking this course. I mean, I get the value in that, but I mean, it's expensive. Those 50-state surveys are expensive. You got a number of them to do, and you're getting a local audience. I know it's questionable. But I do like your disclosure, Tom, about this isn't going to lead to licenses for anything. This is, again, it's a not even a licensed profession like a bookkeeper.
I think it all comes down to what Aaron said, sort of workshopping the language, right? You need to make sure that if you're, you know, Syracuse Technical Institute, and I was going to say, you know, you can use Saugerties. That was my hometown in New York, that no one's ever heard of, and it's not Syracuse, so Jonathan won't feel put upon. If you're going to have a disclosure about a program,
resilient people upstate, don't worry.
We really are. Us upstaters, we can handle anything. Yeah, so true. So if you're going to have a disclosure that is intended, so to Dennis's point, maybe your school is very small, maybe it's a very local market, maybe you don't have the money to invest in a 50-state analysis, and this is assuming a residential program, because I think Dennis is right. Like, once you're in for a penny, you're in for a pound with distance ed. You kind of have to figure it out. But if you're sticking to that local market idea, you have to make sure that whatever disclosure you're using is detailed and really explains the situation, especially if you have something that in your state does not require licensure, but maybe it does in another state, that you're telling students, like, we offer program A in the state of New York. It does not require licensure to practice whatever this is. Our program is not, you know, not have a special accreditation or whatever, which might be required in another state. We encourage you, if you're planning to move to a state outside of New York, to research what the requirements are for those programs and ask questions to make sure that this program is going to meet your needs. Because you don't want there to be any open-ended, like if you just say this program is not intended to lead to licensure. Well, if you're a student, then you're going to think a license is not required to be this profession, whatever it is. Unless you provide the detail of, in this state, it is not a license, you know, you don't need a license, but if you move out of state, you might, and it might require this, that, and the other thing, and please ask questions to make sure this is going to work for you, because you don't want it to be so vague that the student feels like it means they don't have to worry about it. So that's the only thing I would say is, if you're not going to do the big survey, make sure that you're detailed enough in your disclosure that there's no way a student could be confused about what the status of your program is.
Okay,
I agree with all of that. Just the one thing, Tom, just the one thing that I would add, though, is that particularly if you're a smaller school that doesn't have the resources to do this extensive 50-state survey that my colleagues are talking about, one of the options that is available to you is to take advantage of national associations. A lot of these professions have national associations of one kind or another, and those associations often have pages on their webpage that talk about requirements to work in a particular state. So that is a relatively easy matter in many of these areas to go, you know, to do a Google search, find the National Association for that particular occupation, see if they disclose it, and that at least gives you a starting point, so that, you know, if there is a state that has some peculiar rule, that National Association is going to know that, and that might be an easy way to find it.
Okay, for the 200 or so individuals that are still on with us at 3:30, I'm going to do a rapid round of very quick questions for our panelists, and hope that they can do it brief. And for those of you who have hung with us all this time, hang with us for another 3 to 5 minutes, because I have some coming attractions and some information that I think you might want to learn about as well. A couple of the rapid fire questions. Does the certification requirements, disclosure requirements, include the trades such as HVAC, welding, and others?
If in that state, to practice in that profession, you have to have a certification or a licensure from the state, yes.
Agreed.
Next question. If a student enrolled under a non-SARA school agreement as a distance learning student, but moves mid-program, do we need to be concerned with regulatory requirements of the state where they move? Or does the enrollment agreement still qualify while the complaint process change? I'm concerned with distance between state requirements for enrollment and students moving to another state after they've enrolled in an online program.
I think the question here is, do you have to track people's location?
Yes.
And make new disclosures if they change location?
And the answer to that is yes, is it not?
Yeah, I think you need to have a mechanism in place to know if people are changing locations so you can provide them an updated disclosure.
Yeah, and you have to be able to provide that mechanism as to what you do, to the department upon request. I think the question now goes a little bit further too, is that if, assuming that you've done that, if the state has a different standard for enrollment agreements than where the student originally signed one, do you need to have a new enrollment agreement? If they're going there, I think that's a more complicated question. And you may want to have a new enrollment agreement executed once you determine that the student has moved.
And that is something where you would go to council once again in order to work through those very technical circumstances.
Yeah.
Moving on, because we are past our deadline. Coming attractions, just so you know, we have heard that, and you all are all aware that the Title IX regulations have been published as a final rule. They are scheduled to go into effect on August 19th. So look for another webinar on those specific issues, and Jim Moore from the U.S. Department of Education participating at our C-SPEN conference in August, where he will talk specifically about Title IX as it relates to proprietary and private institutions within our community. One of the questions that I've heard that I'll pose to the panelists, but also give you the department statement, is a number of people have been hearing questions about, given COVID and everything else that happened, will all the regs that we just talked about potentially be given an extension like audits and other issues have? The department has said definitively, Anne Marie Wiseman and as well as Diane Howard-Jones have told me no, that these regulations have been out since last year and therefore will go on forward as of July 1 without any further extension. Dennis, Aaron, I'm seeing a lot of shaking of the heads there. So just know that these regulations are set to take effect July 1st and will do so. There is another set of regulations under distance education that have been published in the final rule. We will cover those in a later C-SPEN webinar as well. And just so you know, we are still waiting on yet several other additional packages of regulatory guidance. One's on teach outs, one's on religious faith-based institutions that were part of the last round of negotiations, and yet a third of dialogue and proposal with regard to state authorization. So look for all of those coming in the not too distant future. Shifting back to CARES and the HERF programs, I also, in conversations with Department of Ed officials this week, have been informed that in addition to the guidance just recently published earlier this week, there will be new additional reporting, new additional information on institutional cost reporting and the requirements that go along with that, similar to the reporting requirements of the student emergency grant assistance, and that information will be forthcoming in the not too distant future from the department as well. So, the fire hose is not being turned off anytime soon for any of us in terms of what we're all having to digest and try and comply with and work with. But I want to, in conclusion, say thank you so very, very much to all 6 of our panelists that were on the call today, and for all of their agreement to not only share their wealth of knowledge and information today, but on previous presentations as part of the roundtable discussions that we have offline, and literally all of you, each individually and collectively, do for the community. All of the list of the individuals and the entities are on this. Again, on behalf of C-SPEN, Kate, Roger, Chris, Jonathan, Aaron, Dennis and Yolanda, who couldn't be on the call with us today because she had to deal with a fire for one of her clients. I do want to thank all of you all on behalf of the over 289 registrants and participants for sharing time with us today and for all of the useful information. We look forward to sharing more with you later. Thank you very, very much, one and all, and have a great day.
Thank you.
Bye, everybody.
Got to see Aaron looking at his best.
Good as it gets. As good as it gets.
We will go out in Syracuse.